I'm attorney Sean Garner.
And I'm attorney Adam HANSEN.
We're excited to talk to you about your estate planning options and how you can get your own affairs in order.
We're living in unprecedented times, and now is the time to take action when putting an estate plan in order for you and your family.
Today we're going to talk about how we can help you get your affairs in order. We've been doing business for over 45 years. And we've created over 15,000 plans. Most of our clients come to us with 4 major concerns. They don't want their estate to be taxed any more than absolutely necessary. They want to avoid nursing home expenses or make sure that they don't go bankrupt with those expenses if possible. They don't want their families to be torn apart because of fighting after they're gone, and they certainly don't want to expose their family to lengthy and expensive court proceedings. Most people share those concerns, and if you do, then you may be surprised to find out that 55% of people die without any planning in place. We want to find out why. So we're going to play a little game. What are the top 3 reasons why people don't get planning in place? Let's see how you've done. The number 3 reason people don't get planning in place is costs, or at least concerns about how much it'll cost. The number 2 reason is where to start. Although we have access to more information today than kings and scholars had 100 years ago, it is hard to determine where to get started and who to trust. Finally, the number 1 reason people don't get estate planning in order is simply good old procrastination. If this is you, we encourage you to resolve at the end of this seminar to get something done. We can help you understand how much an estate plan will cost. We can help you understand where to get reliable advice, but only you can determine to get it done and get over that big obstacle of procrastination.
We're going to discuss the 3 options that individuals have when creating their estate plan. The first option is what we call the do-nothing plan. It's what a lot of people do. If you're married, oftentimes you'll put each other onto the account, and the idea is that if one of you gets sick or the other one dies, that you can still manage that asset. And when you pass away, that asset's going to be easily transferred to the other joint tenant. Or you put beneficiary designations on your assets. The second way to do planning is what we call the traditional estate plan. Traditional because we've been doing this for a long time. And a lot of people will execute a last will and testament along with powers of attorney for finances and healthcare. The third type of planning that we're going to talk about is what we call a comprehensive estate plan. A comprehensive estate plan takes the traditional type plan and adds one big key element, and that is what we call a living trust. For the rest of this presentation, we're going to use this made-up family. We call it the Jones family. It consists of Bill the dad, Mary the mom, and they've got 2 kids, Susan and John. Susan is the apple of their eye. She always makes good decisions. She's got a great track record. She went off to college, got married, and then they've got John on the other hand. Look at this guy. He's a deadbeat. He's constantly asking mom and dad for money. He's constantly running around with the wrong crowds, and they just don't know what to do with him. I'm sure there's no Johns in your family. I hate to break it to you, but a lot of families have them, and so we're going to talk about them in this presentation. Bill and Mary Jones have an estate worth $400,000. Now that doesn't mean that they have $400,000 cash in the bank. That means that considering the equity in their house, their cars, their life insurance policies, if they were to die, you put that all in the one big pot, and the value of that stuff added up is $400,000. Now you might be saying to yourself, well, that doesn't look like my family. Maybe you're divorced, maybe you're single. Don't focus so much on the Jones family and their marital status just because it might not look like your family. The principles that we're going to talk about today are applicable to all of us, regardless of your family or your marital status.
Let's start out the analysis with going through joint tenancy. It's holding an asset between 2 or more people. So when a husband and wife own a house together, or a car together, or a bank account together, they hold it in joint tenancy. The same principle applies if a mother and daughter or father and son hold it together. You get the idea. When you hold an asset together with another person, when you hold an asset in joint tenancy, you typically own it with right of survivorship. And that means if one person dies, then the survivor owns the entire asset. Let's apply this to Bill and Mary's scenario. Suppose that Bill and Mary have a talk about getting their affairs in order. Bill explains to Mary that their affairs are already in order. She is on his bank account and the house and the cars, and he is on her bank account. So if something were to happen to him or her, the survivor would automatically own and control it. So there's nothing to worry about. Mary accepts this explanation and they decide to go out on the town and have a date. So they go out to the movies. After they watch a movie, they come back, and on their way back, they're going through an intersection when all of a sudden a truck runs a red light and smashes into their car. Now we're going to see how well their estate plan or lack of estate plan works. First of all, Bill is killed and Mary is seriously injured. So she's going to be spending a long time in the hospital and probably the rest of her life in some type of assisted living or nursing home facility. Now, true to his word, all of Bill's assets do go over to Mary's name. Mary will own all their cars, she'll own the bank accounts, and she'll own the home. But she will need some assistance in managing those affairs and updating the title on all of their assets. Who is going to help her do that? We've got two primary candidates. We've got the deadbeat son, John, or we've got the successful daughter, Susan. Now, of course, most people would choose Susan to be in that role, but Mary, since she hasn't chosen beforehand, it's going to be up to the court to make that decision. And we call this the nightmare of living probate. Probate is a process of the court placing somebody else in control of your assets if you're incapacitated. We enter probate with a guardian and conservatorship matter by petitioning the court to appoint somebody to control Mary's assets. The problem here is it's the court that gets to make the decisions as to who is going to manage the assets. It's time consuming and it's expensive. Once that all gets resolved, let's assume that justice prevails and the court appoints Susan as Mary's guardian and conservator. Now, Susan can make financial decisions for Mary as her conservator and healthcare decisions for Mary as her guardian. As her guardian, she's going to find a good nursing home that will provide all of Mary's needs because they're beyond Susan's capabilities to maintain on a day-to-day basis. In a nursing home, most of you understand that they're expensive, but let's put things in perspective. How expensive are they? Let's say that Mary stays in the nursing home for 25 months until she passes away, which is not an exaggeration considering the national average is 29 months. Let's also assume that the monthly fee is $6,000. That's also not exaggeration. That's generally an entry fee level for a nursing home. Multiply $6,000 by 25 months and the cost to Bill and Mary's estate is $150,000. Now, you may not think that that's going to destroy their estate or bankrupt them, but when you consider that not all of their assets are cash assets, we're looking at another mortgage on the home or quickly liquidating most of the estate to come up with that money to pay for her nursing home expenses. When Mary passes away, she dies intestate. Now that sounds like a horrible disease, dying intestate. But what it means is that the state laws in the state that you pass away govern who is in control of your assets and who will receive all of your property. Most people aren't comfortable with that idea. Mary didn't have a will, so what does this mean for Mary? That means the state will determine between John and Susan who is going to control the distribution of her assets. The court is going to have to appoint one of them as a personal representative and require a bond in order to ensure that they act properly and don't misappropriate or steal the money from the estate. Courts take time and money. On average, it takes about a year to go through an intestate probate, and it takes a lot of money. Let's take a look at the overview of how much it costs Bill and Mary's estate with that current planning or lack of planning. The estate started out with $400,000. The guardian and conservatorship cost them $8,000. The nursing home cost $150,000. And the probate fees were about 6% of the gross value of the estate, so $24,000. Again, remember, it's the gross value of the estate, so even if there's a lien against the home for $150,000, it's calculated against the full value of the home. The total loss to the estate is $192,000. We can do better than that, of what would happen if Bill and Mary had got an estate plan through traditional estate planning, like a will, a power of attorney, and a healthcare power of attorney. With a will and a power of attorney in place, We're going to see how that is going to help Bill and Mary when they go through this crisis. So they go out on a date, and it ends the same way, in the intersection with a truck running the red light. Bill is killed, and Mary again is seriously injured. Now, the assets are still held jointly, so they'll still pass to Mary's name pretty smoothly, although she will need some assistance in managing her affairs when they are in her name. Who's going to do that? Well, with her plan done in advance, she would have appointed already Susan as her power of attorney. So John is not going to come into the picture at this point. With authority to make legal and financial decisions, we get to avoid the court and involvement with the nightmare of living probate. We'll also have a healthcare power of attorney in place so Susan can make healthcare decisions on behalf of her mother. One of those decisions is going to be going to the nursing home, and as we explained, that's an expensive option. After Mary passes away, the question arises, do the assets pass automatically according to the will, or is there some sort of court proceeding required in order for those assets to pass on to Mary's beneficiaries? The answer is, where there is a will, there is a probate. Think about that. You can't take a will into a bank and have the bank pay out the amount in the account from mom and dad to the kids just by showing them a will. You actually have to go to a court and have the will probated or recognized as an official document that's going to control the estate. Somebody's going to have to be appointed as the personal representative or executor of the estate, and they're going to have to be instructed on how to distribute the assets in the estate and make accounting back to the court. The benefit of a will is you don't have to pay a bond if it's drafted and waives the bond, which usually they are. Now, a personal representative is generally selected in the will, so the court has a clear indication as to who is going to serve, as long as they are willing and able to do that. And the court also has clear instructions as to how the distributions should be made. So there are some benefits of having a will in place, even though you have to go through probate. There are also some disadvantages of going through probate. It takes a lot of time and money. On average, it costs about 6% of the value of the estate, and that is the gross value of the estate, and it takes about a year to get through the probate proceedings. You have to give notice to all heirs of the estate, all legal heirs, even if they are people that are disinherited under the will. And you might be subject to multiple probates if you have property in more than one state. For example, if you have real property in Arizona and in Washington, you would have to file a probate in each of those states because Arizona only has jurisdiction over real property in its boundaries, and the same applies for Washington and every other state. Another issue that you're going to run up against is what happens to the inheritance once the beneficiaries receive their share. Think about Susan depositing her inheritance into a joint account because she's married. If she were to get divorced, well, let me introduce you to her husband, Jason. Jason is going to get 1/2 of her assets. Now that's got Bill rolling over in his grave because Jason and Bill never saw eye to eye. But that's oftentimes how it happens if you don't keep the inheritance separate. Now let's take a look at John and what's going to happen with him. He's going to have a big party, spend some money on cars, drugs, have friends coming out of the woodwork, and before you know it, his inheritance is gone. The national average for the amount of time that a beneficiary spends his inheritance is 1 year. That's everything you've earned over a lifetime gone in a year because the beneficiary is not financially mature in some cases. Let's take a look at the total cost of Bill and Mary's traditional estate plan where they went online and did it themselves. Mary was able to avoid the guardian and conservatorship costs, so she saved $8,000 there. However, the nursing home fees were about the same, and the probate fees were about half of what they were from the prior version, the joint tenancy plan. So 3% of $400,000, and remember, it's the gross value of the estate, not what is the net value of the estate. So if there's a mortgage on her home, that doesn't come out of the total fee. That comes out to $12,000 for Mary's probate fees. Mary's total expenses to her estate is $162,000. We can do better than that. And Adam is going to tell you the next option that they have when they get this do-over.
Bill and Mary got a really bad shake. What if they got a do-over? You're probably thinking to yourself, there's gotta be a better way. And there is. Have you ever heard of a living trust? Many of the clients that we meet with, when I mention living trust, a couple things I can just see rolling around in their mind. Number one, trusts are only for rich people. Or number two, that's too complicated for my simple situation. Both of those things are wrong. Trusts are not only for rich people, they're for everybody. And they've actually become one of the best ways to do estate planning for the last couple of decades. And actually, they're more simple than what you would expect from a will or a power of attorney plan. Let me explain. When I think of a trust, I think of a box. A box because you can put stuff into a box, right? Well, that's in a physical sense. A trust is not a box in reality. It's not a physical box. However, it's a separate legal entity. A trust looks a lot like a will. It's on paper, it's typed out, it looks fancy, you sign it just like you would sign a will, it's notarized. But there's a really big difference between when you sign a trust document and you sign your will. When you sign a will, nothing's going to happen while you're alive. It has no force or validity until you actually die. With a living trust, it's the opposite. When you sign a trust document, it's alive the moment that you sign it. You've created a separate legal entity. This separate legal entity has its own name. And guess what? You get to come up with that name. Because it's a separate entity, that means that you can hold title in the name of your trust. So let me explain. In a trust, there are three basic roles. The first role is that of the trustors. The trustors are the people that create the trust. In other words, those are the people that sign the trust. The moment that they sign it, it's alive. And they're the ones that have the power to change the trust. That means that they can change things down the road. They can take people out. They can put people in. They can change who's in charge if they become incapacitated or they die. They are in control. And it's only them that will be in control. They hold the reins. The second role is that of the trustee. The trustees are the individuals that have the power to manage the assets that are titled in the name of the trust. The third role is that of the beneficiaries. It's the best role to be in, really. Why? Because they benefit from the things that are in the trust. So in a typical married couple situation like Bill and Mary, let's say they came to our office and they say, Adam, Sean, we want you to create a trust for us. We would help them design their plan, walk them through the process, and then the most important part of all this, help them get their stuff into their trust. What does that mean? That means that we're going to help them move their accounts into the name of their new trust. We're going to help them move their real estate deeds into the name of their trust. We're going to help them transfer their life insurance policies into the name of the trust. You get the idea. Their assets are going to go from their personal names over to the name of their new trust. Why? Why do we do this? And why is it so much better? The reason it's so much better is because if you think about it, when a person dies and they own property or they own assets in their own name, the only way to get that property or those assets out of the dead person's name over to the name of the beneficiaries is through a legal process, that probate process that we talked about before. But think about it. If I transfer my assets into the name of an entity that doesn't get sick and it doesn't die because it's not a person, and then when I get sick or I die, it has no effect on the titling of those assets. Why? Because I didn't own the assets when I became sick. I didn't own the assets when I died. My trust did. And my trust keeps humming along even though I've passed away. That's the basic idea. When you pass away or you become incapacitated, you don't have any assets titled in your name. They're in the name of the trust. You're probably saying to yourself, well, how much does it cost a year to keep this thing going? Surely there are some fees that we have to pay every year to have our trust operating. No, you don't. This is your trust. You're in control. Remember we talked about your role as the trustor. You are in control. You're in the driver's seat. You get to control your trust and your assets. There are no new income tax forms. You don't have to file some weird tax return every year because you have a trust. Why? Because this is what's known as a pass-through entity to the IRS. They don't even look at your trust. They look at the trustors and their social security numbers as a tax identifier for your trust. Really, it's business as usual. There are no new fees for buying or selling property. There are no new income tax forms you have to file every year. And there's no management fees. We don't want to give you the impression that the living trust is all that you need, because in reality, when we do trust planning for our clients, it's just the main base to a comprehensive estate plan. In addition to the trust, we would always recommend having a backup last will and testament, a durable power of attorney, and healthcare legal structure so that they have a comprehensive estate plan. And if they were to become incapacitated or pass away, those that they want in charge have the right tools and power and authority legally to manage their assets the way that you leave behind. Let's take a look at how things would have played out had Bill and Mary had a trust before they went out on that date night. Let's assume that they came to our office after watching this video and they decide to move forward with trust planning. And we help Bill and Mary transfer their assets into their new trust. And they're so excited to celebrate that they go out to the movies that night. And unfortunately, after the movies, again, this happens. They get in that horrible car accident. Bill's killed instantly. Mary is seriously injured and rushed to the hospital. And now we're going to see how this plan actually works. Now, the way that we've described Mary, is she able to go out and do business on behalf of herself? No, she's in the hospital. Now that we have a trust plan in place, how is that going to play out? Who's going to be in charge? Well, when they came to our office, they said, we want our daughter, Susan, to be in charge if something happens to us. We're going to name her as our successor trustee. That means that she will have the power legally to do things on our behalf under the trust document. We're also going to name her as our power of attorney for financial decision making. In the event that we leave something out of our trust, we want her to be able to deal with it. And if we're in the hospital and we cannot make medical decisions for ourselves, we're going to name her as our agent under our medical power of attorney. What that means is that we can avoid guardianship and conservatorship. Why? Because Bill and Mary did not own their assets in their personal names. They owned it in the name of their trust. And their trust doesn't get sick. It doesn't die. It can't go to the hospital like Mary. That means we get to avoid all the public humiliation that comes with the guardianship and conservatorship action. We get to avoid the court's control over the situation. And we get to avoid all those costs and expenses that come with litigation or court proceedings. After Mary recovers in the hospital, she's not to the point where she can just go home and take care of herself. She's going to need constant care. And we talked about this before. She has to go to the nursing home. And Sean's going to talk about how a trust is one of the best ways to avoid nursing home costs in a minute. But let's assume that their trust helped them to avoid those nursing home costs. Ultimately, when Mary passes away, do you think that we're going to have to go through a probate action to transfer assets from Bill and Mary's estate over to the kids? We don't. Why? Because Bill and Mary didn't own anything in their name when they passed away. Everything was in the name of their trust. And the trust doesn't die just because they died. It keeps living on. And they have somebody named in that trust that has the authority and control to manage the assets the way that they said. And what did they say? They said, well, when we pass away, we want our good daughter, Susan, the trustee, to deliver the assets to herself, 50%, and the other 50% to her brother, John. That means we get to avoid probate. We don't need to file a court action. Susan is acting under the terms of the trust, and she can do that privately. She doesn't need a court to dictate to her how things are done. She can go to the bank on behalf of the trust. She can deal with the motor vehicle department. She can deal with the county recorder. She is in control of the assets, and she's going to be doing what Bill and Mary wanted her to do as it's outlined in the trust document. We get to avoid all the expenses that come with court proceedings, such as attorney's fees, litigation costs, and we get to avoid all the time delay that comes through a court action. And one of the neatest things is we get to avoid that multiple probate issue that Sean brought up earlier. Just because you hold real estate in multiple states doesn't mean you have to go through a probate action. You can use an Arizona trust to hold all of your real estate wherever it's located in the United States, and the trust will control all of that real estate regardless of what state it's in. And you get to avoid probate in all of those states. So let's see how much this estate plan costs the estate. Do you remember how much we started with? That's right, $400,000. We were able to avoid the guardianship and conservatorship because under the terms of the trust, when Mary became incapacitated, we didn't need to go to court to get authority as to who was directing those assets or managing those assets. And Sean's going to talk about how we can avoid nursing home costs using a living trust. And ultimately, when Mary died, we were able to avoid the probate action because nothing was titled in Mary's name. So the total loss to the estate was nothing.
Now, you probably are well aware of Medicare. There's also another program out there of Medicaid, which you may have heard about, but are not as familiar with. We're going to talk about Medicaid, which is a completely different program than Medicare. Medicaid is a program that helps pay for long-term care expenses, whereas Medicare only pays for hospital and other injury or illness-related expenses. Now, the very first thing that you need to understand about Medicaid is when you go down to the office for assistance in getting qualified for benefits, they're not going to be very helpful in providing advice on how to get those benefits. In fact, directly out of their manual, they've been given the instruction to not give advice recommending actions that can be taken to make the customer financially eligible. So this isn't really helpful. What you need to know is that Medicaid is a program that offers broad services and extensive coverage. You don't have to be totally impoverished to qualify for this plan. So let's take a look and see by doing a quiz if these couples would qualify for Medicaid or not. The first couple, they have assets of $700,000. Their home is $500,000. Their home furnishings is $100,000. And if you think about their furniture, their tools, their jewelry, all of that combined, that's what we're considering home furnishings. It's easily that it could have $100,000 worth of assets there. They've got a very nice car. It's a Mercedes-Benz worth $70,000 and $20,000 in their savings account. They've also prepaid their funeral costs with $10,000 up front. Their income is very nice. It's $7,000 a month. The husband makes $4,600 and the wife makes $2,400. Now let's say that the wife goes through a serious medical condition. She has a stroke and she's unable to care for herself, and it's just too much for her husband to care for her on his own. So they apply for Medicaid for assistance to get in-home care and get the assistance that she needs in the house. Will she qualify? The answer is yes. This is an example to show you how broad this program is if you understand how to apply for the benefits. Let's try another question or another scenario. Here's another couple. They have assets worth $100,000, but their asset breakdown looks a little bit different than the last couple. They've got a park model that's worth $35,000. They don't actually own the lot that it's on. They rent the lot. Their home furnishings are only $1,000. They don't have any expensive jewelry or tools. They've really downsized. So really, it's just a couple of knickknacks, and we're going to say it's worth $1,000 altogether. Their Ford Crown Victoria is worth $4,000. And they've got $5,000 socked away in savings. Their retirement in an IRA account is $55,000. Their income is substantially less than the prior couple. They have $3,640. Well, what is that made up of? The husband makes about $1,340. That is just his Social Security income. And the wife makes $2,400. If she were to apply for Medicaid, would she qualify? She has the same exact medical condition. She has a stroke, unable to care for herself. Think about it. Should she and would she qualify? The answer is no. She would actually get denied under these circumstances. And there's a lot of reasons as to why she would get denied. There are criteria that is applied for each applicant to determine whether or not they meet the thresholds, both income and asset-wise, in qualifying for Medicaid. But there are certain types of incomes and assets that are excluded in that determination. Going through the application process, we can help you understand which ones are excluded and which ones are not. However, the living trust, when it's in place, gives us the flexibility to change how the assets would actually be qualified, whether or not they're going to be determined to be excludable assets or non-countable assets, or they're included in the determination of qualifying for Medicaid. So the bottom line is, when you have your assets in a trust and you become incapacitated, you couple that with a law firm that knows what they're doing with Medicaid planning, that gives you the best possible chance to get qualified for the Medicaid benefits that you need and that you've probably paid into your entire life.
Arizona is one of the best places to get your planning done, and there's a few reasons for that. Number one, Arizona does not have an estate tax. That means just because you die in Arizona, the government's not worried about what you died with. They're not going to tax that. We think that's bad public policy. Number two, there's no inheritance tax in Arizona. That means just because you left your stuff to your beneficiaries, they don't have to pay tax on that. It's not considered income in Arizona. The third reason is because of a law that we enacted in 2009. We call it the Arizona Trust Code. And what it does is very unique in the United States. I'm going to use this bottle of perfume to demonstrate why it is so unique. What would happen if you took this expensive bottle of perfume and you dumped it over on the table? That perfume wouldn't last very long, would it? It would dissipate. It would evaporate very quickly. Let's think of the perfume bottle like the living trust, your living trust. Let's think of the perfume, the expensive perfume, like the things that you've worked for all of your life. You don't want that just wasted. In Bill and Mary's case, when they came to us, they said, we want to be able to protect our kids, Susan and John. And as we go through that interview process, they decide to use what we call subtrusts. A subtrust is like a little baby trust within their trust. Instead of the assets going to John personally or to Susan personally when Bill and Mary die, the assets are going to go into a little perfume bottle, a little subtrust. And this subtrust can be very particular to that beneficiary. So what does it look like in John's case? Remember, John had all those issues, drugs and alcohol, always asking for money? Well, Bill and Mary, knowing this, they decide to protect John from himself and to protect everybody else from John as well. And they decide to put John's inheritance into a subtrust for his benefit, but not under his direct control. What would that look like? Well, they decide to put his sister, Susan, in control of his trust. She becomes the trustee of John's subtrust. That protects John from himself, from going out and blowing all of his money or financial immaturity. It also protects John in other ways. For example, if he goes and runs off to Vegas and gets married one night and then gets divorced the next morning, that ex-spouse cannot touch what Bill and Mary left to him when it's in his subtrust. If he gets sued because he stops paying his credit card bills and now they've got a judgment against him, that lawsuit cannot touch what Bill and Mary left to him. If he has to file a bankruptcy because of his financial immaturity, that bankruptcy proceeding does not pull in his inheritance from Bill and Mary. Why? Because it's in this subtrust. So when John comes to Susan and says, "Susan, did you see that big truck at the car lot? My new girlfriend is in love with that truck. Can I get some money out of my account?" Susan can say, "I did see that truck. Did you see that baby blue Prius right next to it? That's perfect for you, John. Great gas mileage and a real chick magnet." You get the idea. Susan can throttle John's spending. What about Susan's inheritance? We're not worried about her decision making. She always makes good decisions. What are we worried about? Her no good bum of a husband, Jason. Well, when we put Susan's inheritance into her subtrust, just like in John's case, she will have ultimate creditor protection. That means that when Jason goes to divorce her when she gets her inheritance, this little subtrust goes with her. It's not subject to the divorce or any of her lawsuits or creditors or bankruptcies. We also do things a little differently. We love technology. Years ago, we came up with an idea to allow our clients to be able to have access easily, quickly, and in their own pocket to their legal documents. We give every one of our new clients this card. It's just a fancy looking USB card, but what it does is it holds your documents on it. So in the event of an emergency, or if you just want to share your legal documents with those that you trust, you can do so through an email, for example. You have access to your own planning. If you need to make a copy, you can pull it up on your computer at home and push print.
Now, of course, everybody likes a bargain, but there are some things in life that you don't want to cut the costs for. For example, if you're going to jump out of an airplane at 20,000 feet, you're probably not going to be shopping at Goodwill for your parachute. If you're looking to get a medical procedure done, even if it's a routine medical procedure like an appendectomy, you're not going to be shopping for a surgeon on Craigslist. The same thing applies with attorneys. There are a lot of attorneys or legal sites out there that provide discount services. But we are talking about putting together an estate plan that will determine how everything you've earned over a lifetime will pass down to your next generation or the beneficiaries that you want to have them and to continue your legacy. This isn't something that you want to cut corners on and pinch pennies. Now let's talk about also what we do when we put together a trust plan. One major difference between the services that we offer and the types of services available either online or at a cut rate legal office is that we follow our clients all the way through in getting their estate plan in order. One critical component of having a comprehensive estate plan in order is the funding of the trust. Funding is the process of retitling the asset out of your name and into the name of your living trust. Now you can go online or you can go to a cut rate law office and have some document prepared, and that might be a beautifully drawn up document. But when it comes to transferring the title of your assets into that trust, that's when you're going to get the gut check. Do I have enough confidence in this trust that's been drafted up that I'm going to retitle my house into it, that I'm going to retitle my bank accounts into it, and all of my savings and financial investments? We help clients fund their trust, retitle each of their assets into the trust, and as we do this, we put to work our expertise and our experience in financial advising to make sure that any tax-deferred accounts don't have any negative consequences when we're compiling them with the trust planning that we put together. We want to be very open and transparent when it comes to our fees. A single plan is $3,095. A married plan is $4,095. Now remember, that's for a comprehensive estate plan. This slide shows a list of services that we provide in that comprehensive estate plan. Now you can look over and read each of these items that we provide, but the bottom line is probably the most important one to focus on. We want a long-term relationship with our clients, and we provide them unlimited consultations. We are confident enough that the plan is comprehensive and going to take care of their needs, and that we can instruct them about how they can manage their own affairs, and we're going to give them unlimited access to our office, clarify any questions that come up, and questions will come up, but we'll be there for you to address those issues and make sure that relationship is established in advance. So when the crisis strikes, you're not trying to get to know somebody at that time. You have somebody you trust to walk you through those issues. For attending this seminar, you get a $200 seminar credit. Why would we give that to you? Because you've been proactive in educating yourself about what it takes to get a comprehensive estate plan in order. That saves us time when we're working with you as a client, and it also saves you time because you have things queued up in your mind when we go through the consultation. So we pass on those savings to you, but there are 3 criteria that you've got to meet in order to get that $200 credit. First of all, you've got to schedule an appointment today or within 24 hours of watching this seminar. Next, you have to determine in your mind that you're going to make a decision. You're not going to procrastinate getting your affairs in order. So, determine whether or not we're right for you or whether we're not right for you, but make sure that when you come into that appointment, you're ready to make a decision. No is an okay answer, but if we're the right firm for you, let's move forward without delay and get you on the calendar to get your trust signed. Remember, there are 3 major reasons why people don't get planning in order. We've talked about costs. We've talked about where to go to get reliable information about how to get your plan in order. Now we're down to that number 1 reason people don't get planning in order, and that's procrastination. This is where you come in. Make the call, set up an appointment, and let's see if we're the right fit for you. Many people are really concerned about the crisis or the epidemic and the lockdowns that are going on right now with this COVID-19 or coronavirus. This is one example of why you don't want to procrastinate your planning, and we've also taken major steps to make sure that people that don't have everything in order now continue to go forward to get their planning in order. We have appointments only for individuals that come into our office, so we are not going to have multiple people in the waiting room at the same time. So when you come in, you will ring a bell and actually get in from the side door. You'll come directly into the attorney's office, which has been cleansed and sterilized between each of our clients, and be able to consult with him directly. You're also able to do a consultation over the phone if that's what you prefer, and we can do an online consultation, basically a virtual consultation if you want to do it through Skype or FaceTime or any of those other apps.
I concur with Sean. These are unprecedented times, and we need to take action now. It's no time to procrastinate. Your next step is to click on our calendars. We will make available to you exclusive time slots so that you can set an appointment on our calendars directly and meet with either Sean or I. In that consultation, we'll talk about the particulars of your family. This isn't a one-size-fits-all. We'll ask you questions about what you have, and then we'll put those 2 things together. Your family dynamics, the things that you currently have or will have in the future, and then we will make recommendations as to what the best plan would be for your particular family. Don't procrastinate. Set an appointment today. We're so excited to help you get your planning in order. If you already have a trust plan or you have an old will and power of attorney, that's okay too. Bring what you have. We can review it. And let's see if we can help. Thank you again for tuning in. We can't wait to meet with you.